Welcome and thank you very much for joining us on our Fox Williams annual Data Protection Update webinar as we approach the 4th anniversary of the GDPR coming into force across Europe. Of course, we in the UK have since left the EU, but we have incorporated the GDPR into the UK law. So at least for the time being, we've pretty much the same data rules as in the EU. So my name is Nigel Miller and I'm one of the partners in our tech and data team. And I'm very pleased to be joined today by my colleagues Kolvin Stone, another partner in our team, and Vlad and Prachi, who are associates in our team. And here's what we're going to be covering today. Kolvin's going to kick off with recent enforcement actions and what lessons we can learn from them. Then Prachi's going to look at the new EU and UK international data transfer rules. I'm then going to look at dealing with DSARs. And then last, but certainly not least, Vlad is going to look at what lies ahead, given that we've got a new ICO and a UK national data strategy following Brexit. Now, although there's a lot of detail on all of these issues, within this hour, we're going to keep things at a pretty high level. Please do submit questions on the chat as we go along or ask questions at the end. We're going to do our best to answer, but we do have a very large number of people on the call and we won't have time to address the questions. So please do feel able to contact us directly after the webinar, either by email or otherwise, if you need any more information or help, or if you've got any questions, and we'll be more than happy to respond in the coming days. Anyway, this webinar is being recorded and we will circulate a copy of the slides and also a link to the recording afterwards. So there's no need to have to sort of rush to scribble notes as we go along. So I'm now going to hand over, first of all, to Kolvin to look at recent enforcement actions and lessons to be learned.
Thanks, Nigel, and welcome, everyone. So in this section, as Nigel said, I'm going to be looking at recent, what I would call sort of interesting enforcement actions, where we can learn some lessons. But before that, I'm just going to touch on a few kind of trends. So I think it's fair to say, over the last few years, we've seen an increase in enforcement activity. So both in terms of the number of fines and also the level. So if you just look at it from a UK perspective, in 2021, the ICO imposed 32 monetary penalties compared to 17 in 2020 and only 1 in 2019. So you can see a trend there in terms of an increase, certainly in the number of fines. So far this year, there's been around 15. So we're on a kind of similar pace to last year. However, I think one interesting data point is that the size of the penalties has radically fallen compared to late 2020, where we saw multi-million pound fines for data breaches levied at BA and Marriott. So the sort of decrease in the level of fines contrasts with the EU, where the trend has been a significant increase in the size of fines. So particularly in the last 6 months, so we've got WhatsApp, which I will talk about a little bit later, at sort of 225 million euros. Amazon last year, which was 750 million euros. And this week, Google was fined 10 million euros. So that's quite a change from the UK, where we've not seen any multi-million pound fines. So it's too early, I think, to say whether this is a trend which demonstrates a permanent shift in approach by the ICO and a divergence in strategy from the ICO's EU counterparts. I think we'll know more later this year when the ICO publishes its regulatory action policy. So that will give us an indication of its approach to enforcement and also its priorities. So we're expecting that in the next few months. In this context, I think it's worth noting the comments of the new Information Commissioner, John Edwards, who wants to position the ICO as business friendly, which also reflects the government's agenda in a post-Brexit world. So on the issue of fines, he said recently in his first sort of public speech that fines are a slow way to find certainty. Instead, Edwards said he's forming the view that significant enforcement efforts must be used with surgical and targeted application. So that suggests he doesn't see widespread fines as an effective way to drive compliance, and could mean that we're unlikely to see an increase in the use of monetary penalties. But I wouldn't rule out the ICO and Edwards targeting high-profile businesses and marquee fines. So Edwards has, from his time as the data regulator in New Zealand, has a reputation as a critic of big tech. So his approach could also align with the approaches of EU regulators, where they've been targeting the likes of Google, WhatsApp, and Amazon as a way to drive compliance. Next slide, please, Jess. So on that note, the first case I want to look at is WhatsApp. So last autumn, WhatsApp was fined 225 million euros by the Irish Data Protection Commissioner for a number of failings related to its compliance with the GDPR transparency requirement. So this is the requirement to provide information to individuals about what you're doing with their data. So that fine is the second highest handed out under the GDPR today. And the decision really sheds light on some of the key issues to be taken into account when drafting and updating privacy notices. So I think it's really important from a practical compliance perspective, because it gives an insight into what regulators think should be in your privacy notice, and ultimately how you should express it. So many of the practices for which WhatsApp was fined, I would say, are relatively standard. So that does suggest that there needs to be a change in the way that people draft and present their privacy notices, particularly with regards to in the consumer technology space. So what are the key lessons learned? In particular, you should not use vague wording to explain your purpose for processing the data. So, for example, will your readers know what you mean if you say that your use of their data is for the purpose of improving experience? You need to be specific. Don't simply say that you rely on legitimate interest to carry out a certain type of processing without actually mentioning what your interests are. You need to be granular. Don't use conditional language such as may when referring to, for example, reliance on a transfer mechanism. So, for example, we may transfer personal data internationally on the basis of standard contractual clauses. Be certain. You need to say what you do. And lastly, don't link excessively to external documents in your privacy notice, particularly where they might duplicate or, in some cases, contradict information that's actually in the notice. Readers should ultimately not have to work hard to try and get to grips and understand the notice. So you need to really make sure that it is accessible and easy to follow. And on that point, much of the Commissioner's decision was really focused on the way in which WhatsApp presented the information in its privacy notice. There were numerous instances of overly complicated, unclear, and inaccessible language that users simply, as far as the regulator was concerned, wouldn't be able to follow or understand. So what is clear is that regulators expect you to be more granular and specific, but also want notices to be concise and easy to read. So that's not an easy line to tread. And there is a tension, a recognized tension, between being granular on the one hand and trying to be concise and accessible on the other. Next slide, please. Yes. So the other matter I'd like to mention relates to ransomware. So ransomware attacks are on the rise, especially with the tensions between Russia and the West at the moment. And the National Security Centre considers ransomware the biggest cyber threat facing the UK. So with this in mind, and recognizing the risk is real for all businesses, large or small, and the ICO makes this point that often attackers are not looking at large businesses, they're also looking at small businesses. It's important to understand how the ICO views ransomware attacks. So in March of this year, the ICO fined Tuckers, which is a criminal law firm, £98,000 for failing to take appropriate measures to safeguard against a ransomware attack. Now, this is important because it's the first time the ICO has issued a fine relating to a ransomware attack. And whilst Tuckers was ultimately a victim of a criminal act, it demonstrates that the ICO will not look kindly on organizations that fail to take appropriate measures. So what happened in the case of Tuckers? It was an attack that resulted in the encryption of almost 1 million individual files, of which 25,000 were court bundles related to Tucker's clients. So quite sensitive, privileged and client information. Of that, 60 court bundles were exfiltrated by the attacker and published on the dark web. So there was not only unauthorized encryption, but also exfiltration and disclosure of the data. And in this case, the ICO makes the point that both those scenarios represent a data breach. So both the unauthorized encryption and ultimately the disclosure. The ICO identified a number of failures by Tuckers, I think, which serve as a helpful reminder of what is and isn't good practice. So firstly, there was a failure to appropriately manage patches. So i.e., not implementing patches in a timely manner to guard against known vulnerabilities. And in Tucker's case, they took 4 months to implement a patch to fix a vulnerability that was the likely entry point for the attackers. Secondly, not using multi-factor authentication for remote access. So the remote environment is where the hacker operates. Ultimately, that's their point of entry. And the ICO considered that multi-factor authentication was a comparably low-cost preventative measure that Tuckers should have implemented. Lastly, not using encryption, particularly as regards archived data. The ICO noted that the encryption of personal data may not ultimately have thwarted the attack, but it would likely have mitigated some of the risk around the subsequent data exfiltration. Also, it was a relevant factor that encryption is commonly used in the legal industry, but it was not used by Tuckers. And often when the ICO is deciding whether you've taken appropriate measures, it looks at common industry standards. So following this, the ICO has published some specific guidance on ransomware attacks. So it was very shortly after the monetary penalty that was levied on Tuckers, which really takes the form of a checklist for organizations to follow to ensure they have sufficient protections in place to guard against ransomware attacks. So the guidance focuses on 2 key requirements. Not surprisingly, technical controls to minimize the risk of an attack. So things like multi-factor authentication, encryption, etc. And also the policies and procedures that you should have in place to prevent and or react to these attacks. So it's things like incident response plans, disaster recovery and business continuity plans, and staff training. And the key takeaway from the ICO is that you should be reviewing this guidance and then updating your technical controls and policies to reflect the guidance. And ultimately, if that's not something that that you do, and a breach becomes notifiable to the ICO, they will ultimately judge whether a breach of the GDPR has occurred or not by reference to the guidance. So complying with the guidance is an important way in demonstrating that you've taken appropriate measures to guard against a ransomware attack. So now over to Prachi, who's going to talk about international transfers.
Thank you, Kolvin. So starting with the UK and European data protection regimes have had developments due to Brexit, and transfer mechanisms in particular have been tricky. Most data can flow freely between the EEA and the UK, but where a party intends to transfer data to any third country, which is a country or territory outside the UK and the EEA, this is considered a restricted transfer, and both the UK and EU GDPR set out requirements that must be fulfilled to give effect to such transfers. For the purposes of this webinar, when we refer to restricted transfers, we will be talking about restricted transfers to third countries, which are not recognized as having an adequate level of protection by the UK government or the European Commission as relevant. So where an adequacy decision or a derogation does not apply, such restricted transfers will need to have appropriate safeguards in place. And today we will be discussing one of the most common appropriate safeguards used to legitimize such transfers, the standard contractual clauses and the international data transfer agreements and the UK addendum. Next slide, please. So moving on to the documents themselves, firstly, the European Standard Contractual Clauses, or the EU SCCs, are the ideal transfer mechanism to use for restricted transfers of EU data. As you may know, there are different versions. The original set of EU SCCs were adopted by the European Commission under the 1995 Data Protection Directive. We will call these the old EU SCCs. However, the old EU SCCs do not cover requirements of the UK GDPR or reflect the lessons learned from CJEU's decision in the Schrems II case in July 2020, which still applies in the UK as it was handed down pre-Brexit. So it was a matter of time that another long-term solution had to be devised. So the European Commission published the new set of EU SCCs on 4th of June 2021. We will call them the new EU SCCs. And while these new EU SCCs did take into account the Schrems II decision, having been adopted after Brexit, they were not valid for restricted transfers to which the UK GDPR applies. The new EU SCCs took effect on the 27th of June 2021, and the old EU SCCs were repealed as of 27 September 2021. Now, the new EU SCCs do have some limitations that party using these must be aware of. Firstly, these only cover 4 types of data processing relationships: controller to controller, controller to processor, processor to subprocessor, and processor to controller. And so while this is an improvement on the old EU SCCs, this still does not cover all scenarios that may be possible. For example, a processor transferring data to another processor who isn't its subprocessor and may have been appointed by the instructing controller separately. The new EU SCCs are also not suitable for restricted transfers to data importers who are directly subject to the EU GDPR due to its extraterritorial application. The European Commission and the European Data Protection Board are working on a new module of the EU SCCs to cover such transfers, but for the time being, it remains unclear as to which appropriate safeguard should be used for such transfers. In terms of using the SCCs, instead of signing these as a separate document, parties may incorporate these within any existing contracts, which may currently be using the old EU SCCs, by reference, provided that the parties specify the module that applies to their processing relationship, example, controller to processor, etc. This can be done by adding a clause in the contract stating that the parties agree to incorporate the new EU SCCs in their entirety with the relevant modules. However, the parties must still ensure that relevant clauses and annexes of the new EU SCCs are appropriately included and completed. So for sometimes parties whose processing of personal data was subject to both of the GDPRs relied on the EU SCCs only, and the UK did not have its own transfer mechanism documents which parties subject to the UK GDPR could adopt. But finally, on the 21st of March 2022, the new IDTA and the UK addendum came into force to be used for transfers of UK personal data to third countries. Next slide, please. So the IDTA is the UK's equivalent to the EU SCCs and provides an appropriate safeguard required under the UK GDPR to transfer UK personal data to third parties. This document does not take a modular approach like the EU SCCs and is split into 4 parts. Part 1 includes the parties' details, signatures, their position as importer or exporter, details of the transfer itself, security requirements, and any other commercial provisions which the parties may wish to add. Part 2 contains extra protection clauses. Specifically, this allows for any additional safeguards or supplementary measures as required by the Schrems II decision. and the European Data Protection Board's associated recommendation on supplementary measures to be listed by the parties. Part 3 contains commercial clauses. Now, the IDTA takes into account that more often than not, parties using it will have a linked agreement, which will be the main agreement in relation to the commercial relationship, which requires the transfer of data, and that most commercial terms will be recorded in this linked agreement. So parties have an option of adding commercial terms in the agreement or in the IDTA. Parties must be careful, however, when adding commercial clauses to the IDTA, because if these unintentionally reduce the level of protection of the IDTA, then the data transfer may be in breach of the UK GDPR. The nitty-gritty of the importer and exporter obligations are contained in the mandatory clauses in Part 4, and very limited changes by the parties can be made to this part. The IDTA is generally being viewed as a more flexible and workable document as compared to the EU SECs. For example, clauses which are not applicable may be deleted by the parties so long as all other clauses are accurately incorporated and cross-referenced and do not reduce the effect of the appropriate safeguards. In case the parties make a mistake in specifying their positions or their processing relationships as controllers processors, the wrong choice will be ignored and the facts will apply. And as mentioned above, the IDTA generally takes into account that parties may already have another main agreement and allows for the incorporation of the terms of the linked agreement. And finally, the IDTA does cover transfer to importers in third countries who are directly subject to the UK GDPR on an extraterritorial basis. Moving on to its limitations, the IDTA does not address any of the Article 28 requirements or the data processing terms when the importer is a processor, while the EU SECs deal with this. The parties will have to think about these and cover these separately when using the IDTA. In terms of using the IDTA, this is a standalone agreement and parties can access this through the ICO website. The ICO is yet to confirm this. However, the frequently asked questions in the consultation draft issued by the ICO last year pointed towards the fact that the IDTA may be signed by parties, but it is possible to make the IDTA binding without signing the document by making it clear that parties agree to its terms. But it is expected that this point will be clarified by the ICO in its upcoming guidance. Next slide, please. So the International Data Transfer Addendum, or the UK Addendum, is the other document that was published by the ICO to cover transfers of personal data from the UK to third countries. This document will make the new EU SECs work for transfers of data to which UK GDPR applies along with EU GDPR. The use of the new EU SECs with the UK Addendum is likely to become one of the most preferred transfer mechanisms going forward. The document contains a similar structure to the IDTA, but only has two parts. This includes a table for parties to fill in their details and information regarding the EU SECs that they are appending the UK Addendum to, and then the mandatory clauses. In terms of limitations, since the UK Addendum can only be used with the new EU SECs, the limitations of the new EU SECs covered above will also apply here. And some of the definitions in this document can slightly be confusing and make it difficult to understand the order of precedence in case of conflict between the contents of the document and the data protection law in the UK, example, addendum and approved addendum. In terms of using the UK Addendum, this is a freestanding document, again, to be appended to the new EU SECs, which should be signed by the parties, but we're again awaiting some further clarification and guidance from the ICO. Next slide, please. So when using the documents we just covered, an important question that is raised is whether a transfer risk assessment is needed for every restricted transfer. As per the Schrems II decision, when the country to which the data is being transferred to cannot guarantee essentially an equivalent level of data protection to that of the EU, additional measures may need to be put in place alongside the appropriate safeguard. This means that when relying on the SECs, risk assessments will need to be completed. Parties will also be required to carry out risk assessments when relying on the IDTA and the UK Addendum to make a restricted transfer. Under the IDTA, the data exporter undertakes the transfer risk assessment and provides a copy to the importer on request. However, under the EU SECs, both parties will have to undertake this. Next slide, please. So going forward, there are a few key dates for parties to be aware of. The first important date for UK transfers was 21st of March 2022. And from this date on, UK exporters can start using the IDTA and the UK addendum to cover restricted transfers. The second important date for UK transfers is 21st of September 2022. Up until this date, parties can still choose to use the old EU SCCs to cover the new restricted transfers from UK. However, new restricted transfers from the UK after this date will need to be covered by either the IDTA or the new EU SCCs with the UK addendum. Contracts concluded before this date, which include the old EU SCCs, will remain valid until 21st of March 2024, unless the processing operations have changed. The next important date pertains to EU transfers, which is 27th of December 2022. And contracts using the old EU SCCs to cover transfers of data from the EEA concluded before 27th, 2021, which was the date when the old EU SCCs were repealed, will remain valid up until this date, provided that the processing operations haven't changed. And after this date, all EU transfers must be covered by the new EU SCCs. And finally, on 21st of March 2024, the two-year transition period will expire, and all new restricted transfers of personal data from the UK will need to incorporate either the IDTA or the UK addendum. We are also expecting some guidance from the ICO, which will be helpful for the parties to use the documents, including a clause-by-clause guidance on the documents and on how to use them, and guidance on transfer risk assessments, and further clarification on the international transfers guidance. It is also important to note that any revisions to the IDTA or the UK addendum made by the ICO in the future will take effect automatically. However, the UK addendum contains additional provisions which allow parties to choose termination, where such revisions will cause a substantial, disproportionate, and demonstrable increase in that party's costs or risk. Next slide, please. So generally, this is an important time for businesses to review their data flows and identify where data transfers are made to third countries and where you may be receiving data pursuant to restricted transfers and which regime will apply to such transfers. It's also important to identify which documents are currently being used in respect of such transfers and which ones will be updated or replaced. The above steps should be taken considering the upcoming renewals or renegotiations of key contracts and allow for adequate time for new documents to be incorporated where necessary. It is also important to understand the key aspects of the new documents and see how they fit into your overall privacy and governance structure. For example, if you're receiving data, consider if you need to flow down any new requirements for onward transfers. There may be several moving parts involved in updating your documents to continue to make compliant data transfers, and it will be important to understand all the relevant requirements. I will now hand over to Nigel. Thank you.
Thanks very much, Prachi. So turning now to the question of data subject access rights, or DSARs. Putting data subjects in control of their data was a central pillar of the GDPR. And data subjects have a number of different rights, but probably the most used and probably the most controversial one is the right of access. It's interesting to note that in the last year, the ICO reported that 46% of complaints that they received in respect of general non-compliance with data protection was to do with the right of access. So it's an area of great focus. The Dsar right was intended to allow individuals to check on what personal data an organization has about them, how it's being used, and that it's accurate. But in a classic case of unintended consequences, the GDPR has actually given rise to the weaponization of these requests, as they're frequently used as a means of pre-litigation discovery or disclosure, particularly in relation to HR-related disputes. Now, as many of you I'm sure will know, responding to DSARs can be a major time and cost overhead and can be highly disruptive. So by way of overview, what I'm going to cover now is first look at the basic right of access, then look at some specific timing issues in relation to delivery of the information, some problematic areas with regard to searching, the exemptions to providing information, and finally, enforcement of DSARs. I'm going to refer to the current guidance issued by the ICO, which was recently updated, and also to some recent guidance from the European Data Protection Board, which was issued in January 2022, which, although not directly binding on the UK, is instructive in terms of the way regulators think about subject access rights. Next slide, please. So looking briefly at the basic GDPR right, hopefully you can see from the slide that there's really three elements to this. One is that you have to provide confirmation as to whether data is being processed, not normally controversial. Then the main point, which is access to the data itself. And then also the right to receive certain information, which is set out in Article 15. And I'm not going to go into the detail of that. It's not usually controversial, and in fact should mirror the information which a data subject already has if they receive the privacy notice, as it covers pretty much of the same ground. So under Article 15, the controller has to provide a copy of the personal data. You can either do a direct copy or you can sort of copy and paste it into a separate document. Doesn't really matter whichever works best. And under Article 12, the information has to be provided in a concise and intelligible form. So perhaps in that case, it's best not to ask a lawyer to prepare the information. Next slide, please. In terms of timing for dealing with a DSAR, this is one of the more contentious issues. The basic provision is that you have to comply with a DSAR without undue delay and at the latest within a month of receiving the request. So it's not a question of waiting until the last possible minute to provide the information. It should be provided as soon as possible. The time starts when the controller receives the request, not necessarily when it notices that it's been received. So it's quite important that you have a process in place for staff to be able to recognize and identify when a request for information should be treated as a statutory DSAR, because there's no particular form that has to be used for a DSAR, so it's not always easy to tell. And an individual can make a DSAR request verbally, or they can do it in writing in whatever format they want, including on social media. So important to monitor those different channels and make sure people are alert to the possibility that there might be a subject access request. So if, for example, you receive a request today, 19th of May, the time starts from today, and that gives you until the corresponding date in the next month to comply with the request at the latest. So that will be the 19th of June. But in this case, the 19th of June is a Sunday, so the last day then would be the next working day, which is Monday, the 20th of June. So although it says a month, in terms of the actual number of working days, it can vary a little bit, and some months may be a little shorter and some a little longer. Next slide, please. So the controversial bit of this is that you can extend the time for responding by a further 2 months to make it 3 months, but only if the request is complex or you have received a number of requests from the individual. In practice, in cases of DSARs which involve a lot of underlying complexity or potentially a dispute, often cases where lawyers get involved, then controllers will look to rely on this complexity ground in order to extend the time frame for responding, maybe genuinely complex or just playing for time. This can be an automatic reaction on the part of some controllers. The ICO has said that the extension should only be used in exceptional cases. The European regulators seem a bit cooler. They say the possibility of extending the time frame should not be overused. Now, requests that involve a large volume of information may add to complexity, but a request is not complex simply because the individual has requested a large amount of information. So the mere fact that responding to a request is going to take a lot of time and effort doesn't make it complex, and nor is a request complex because you might be receiving a large number of subject access requests to respond to. And it's not also complex because you have to rely on a third-party data processor to provide the information. The regulators perhaps a little bit optimistically expect that a controller, especially one who handles a large amount of data, should have routines and mechanisms in place in order to be able to handle requests within the time limit under normal circumstances. So next slide, please. Whether a request is complex depends on the specific circumstances of the case. For example, what are the resources available to the organization may be a factor. And the regulators have given a number of examples of factors that may add to complexity. For example, technical difficulties in receiving information, if it's electronically archived, for example, where specialist work is involved to get the information or to put it in an intelligible form, or if you need specialist legal advice on, for example, dealing with exemptions. Getting legal advice is always complex, but if you routinely obtain legal advice, then they say that's unlikely to create complexity. The need to review the information in detail and possibly redact information when an exemption applies, I'm going to look at that in a moment, may also add to complexity. So if you do extend the time frame for responding, you have to inform the individual that you're doing so within a month of receipt of the DSAR, together with the reasons for the delay. But ultimately, it's the controller's decision whether or not to extend the time frame. And in reality, an individual has limited recourse if a controller decides to do so, other than maybe complaining to the ICO. But even then, the ICO is unlikely to get too involved where there's at least an arguable basis for using the extension, so long as the controller is actually going to meet the DSAR obligations by the end of the maximum 3-month period. So in reality, although the criteria are quite strict for the extension, a controller does have a degree of discretion as to when they apply it. Next slide, please. Getting clarification. So if you receive a DSAR which is very broad in scope, for example, requesting copies of all my personal data, and if you hold a large amount of data, then you can ask the data subject to clarify the scope of their request, perhaps by providing search parameters and topics of interest. The benefit of doing this, aside from potentially limiting the size of the search, is that it has the effect of stopping the clock, meaning that the time frame for responding is going to be paused until the individual provides you with the clarification that you requested. That stopping of the clock needs to be explained to the individual when you request clarification. So the ICO says you shouldn't do this on a blanket basis. You can only do it if the information is genuinely, that the subject is looking for is genuinely not clear and clarification is needed, and it's a large amount of information. So it's a bit limited, but will apply in many cases. But you can't force an individual to narrow their request. They're still entitled to ask for all information you hold about them. And if they refuse and say no, they still want all the information, then you have to carry out the search and exercise some reasonable parameters yourself in terms of what's going to be most useful. But if the individual doesn't respond at all to your request for clarification, and time goes on and maybe the month elapses, then at that point you would be entitled to let them know that you're not taking any action on the DSAR because of their failure to clarify. But you would need to let them know about that. Next slide, please. So checking ID, again, at the outset, it's important obviously to make sure that you provide the information to the right person. And you need to be satisfied that you know the identity of the person who's requesting it, so that you don't give someone else's information to a third party. Therefore, if you've got any uncertainty about it, you should ask for information to verify the individual's identity. And often people who request DSARs will provide that as part of the DSAR itself. You've got to be a little bit reasonable and proportionate about what information you request. Perhaps a little bit of a risk assessment according to how sensitive the data is and how much diligence you need to do on the identity of the requester. If you do ask for ID information, again, it does affect the timing. In this case, the timescale for responding doesn't begin until you've received the requested verification information. But of course, you've got to request it promptly, and you can't delay requesting the information after you've received the DSAR request. Next slide, please. Providing information, just a couple of points to note. First of all, just to emphasize that, of course, it's limited to personal data as defined, and so should be information about the individual. That would exclude extraneous information about the business or the company, or the fact that someone attended a meeting or was sent or received an email is not necessarily personal information about them. It's got to be something about them specifically. Archived and deleted data can be problematic. It can be more complex to access that than live data, but there's no technology exemption here. The ICO is not so sympathetic. They say controllers should have procedures in place to find and retrieve personal data that has been archived or backed up. On the other hand, if you've actually deleted information in accordance with your data retention policy, so that you have no intention of accessing it again, then you don't need to recreate it, even though that may be technically possible. There's a distinction there between archiving and deletion. But what about personal data stored on devices belonging to your staff, such as smartphones and home computers, or in private emails or WhatsApp messages and the like? So remember, if you're responsible as controller for all personal data, if you allow staff to hold business-related personal data on their own devices, then they may be processing that data on your behalf, in which case it's within scope of the DSAR. In such cases, it can be problematic to have to search employee personal devices, and so it can be good practice to have a policy where you limit staff from holding personal data on their own devices about your customers or staff or contacts. In terms of security, if the information is at all sensitive, then think about how you would deliver it, perhaps encrypted, password protected, or on some sort of platform. Next slide, please. Other circumstances where you can refuse to respond to a request. Well, the main one is, as provided in the GDPR, if the request is manifestly unfounded or excessive, then you can either charge a fee or simply refuse. And there is guidance on what that means. Obviously, these are quite limited circumstances. There has to be a degree of sort of maliciousness around it, no intention to access your personal data. Perhaps someone makes an offer to withdraw it in return for some sort of benefit or payment. And an excessive DSAR would be where you get repeated requests for the same information without reasonable intervals. It's not excessive simply because of the volume of information requested. It's more to do with the repeated nature of the requests. And so then there are, on the next slide, please, there are a number of specific exemptions. There's a large number which are set out actually in the Data Protection Act, which has to be read alongside the GDPR. I'm not going to look at them all, but just to pick up a couple that are more frequently used. Legal professional privilege. Information is exempt from disclosure if it's legally privileged, such as confidential legal advice. And confidential references. So personal data included in a confidential reference is exempt, whether you have given the reference or received it. Third-party rights is quite a thorny one. The GDPR says you have the right to obtain a copy, but that must not adversely affect the rights and freedoms of others. And this can be a little bit tricky because it creates an awkward balancing exercise. It's a bit of a case of damned if you do and damned if you don't. The exemption says you do not have to disclose information which identifies another individual, except where the other individual has consented, or it's reasonable in all the circumstances to disclose anyway. So a bit of a decision there. Do you get consent? Do you seek consent? Or do you feel that you should disclose anyway? Next slide, please. Just looking on briefly at finally at enforcement. There are perhaps two main routes here. If you're the individual who's put in a DSAR and it's not been responded to either at all or correctly, you can obviously make a complaint to the ICO. Recent enforcement actions by the ICO indicate that if a data subject complains, while they may follow up with the controller and ask questions, and may in some circumstances issue an enforcement notice, it's very unlikely that they're going to issue a fine for non-compliance with a DSAR. They may issue a fine for non-compliance with an enforcement notice, but that would be a much more serious thing. And then, of course, there is the possibility to apply to the court for an order requiring the controller to comply. It's a matter for the court's discretion then whether they make that order, and it raises one of the, again, a contentious area about where DSARs have been issued for mixed motives, perhaps where the DSAR has been issued in the context of a wider claim or litigation. The GDPR itself doesn't care about your reasons for issuing the DSAR, unless it's manifestly unfounded or excessive as we just looked at. But the courts don't really like DSARs to be used as a form of pre-action disclosure to further litigation. So there are circumstances where the court might exercise their discretion to say, yeah, we understand about the DSAR, but we're not going to make an order in this case. So that's all I'm going to cover, and so thank you. And I'm now going to hand over to Vlad, who's going to look at what lies ahead for data protection.
Thank you, Nigel. Good afternoon, everyone. So today, as Nigel said, I'll be talking about the future of the ICO and the UK's national data strategy. Dealing with the ICO first, the ICO wants to ensure that data protection can enable innovation and maintain high standards and accountability to play a crucial role in the delivery of the national data strategy. They act as a regulatory backstop whilst encouraging the growth of technology and innovation. Playing a vital role is the importance of baking data protection into new technologies and products, especially when they're developed at a fast rate and following a privacy by design and default approach. The National Data Strategy, which was introduced at the end of 2020, aims to free up businesses and organizations so that they can keep using data to innovate, experiment, and drive a new era of growth. It seeks to harness the power of data to boost productivity, create new businesses and jobs, improve public services, and position the UK as the forerunner of the next wave of innovation. But this means maintaining a regulatory regime that is not overly burdensome for smaller businesses and supports responsible innovation, and ensures that data can be leveraged to deliver and innovative services, promotes strong competition and better prices and choices for consumer. Next slide, please. So the ICO, well, the ICO wants to reduce, as Kolvin said earlier, the burden on businesses whilst ensuring that data can be shared quickly, efficiently, and responsibly for public good. They want to do this by making it easier to use, share, and repurpose data for research. They recognize the significant public benefit research can bring when conducted with appropriate safeguards. And this is reflected in the ICO's recent response to the government's draft strategy titled Data Saves Lives, Reshaping Health and Social Care with Data. And that's where they proposed a statutory condition for consideration, I should say, for the ICO in regards to economic growth and competition, so that the ICO can support the use of data and deliver economic benefits to the UK, as long, of course, as this is done with appropriate protection. The ICO also proposes a statutory regard for public safety, and this is demonstrated by the ICO's data sharing code, which sets out examples of how organizations can achieve this. As Prachi mentioned earlier, there is also a focus on international transfers. The IDTA and the addendum have been created to replace the current SECs that are no longer in use, and guidance clause-by-clause guidance will be provided by the ICO, but that's yet to be confirmed as to when that will come out. Next slide, please. So the ICO has also focused on anonymization and pseudonymization. They're currently releasing a chapter-by-chapter consultation on anonymization. The first and second chapters were published in 2021, with the third and fourth chapters published earlier this year. Chapter 3 deals with what is meant by pseudonymization and also the key differences between pseudonymization and anonymization. The guidance is full of useful information on how to approach the topic and also the offenses under the Data Protection Act for individuals trying to re-identify pseudonymized data. Chapter 4 deals with governance approaches to anonymization, the factors that are needed to ensure transparency, for instance, the data impact assessments, and also how organizations need to stay on top of legal changes. It also provides guidance on relevant legislation when disclosing anonymous information. Next slide, please. Another area that the ICO is looking at is cookies. In the opinion of the new commissioner and in response to the DCMS consultation, there needs to be a shift towards less intrusive tracking and profiling. The proposals are to phase out the use of third-party cookies and cross-site tracking with alternatives, if they work, that is, such as Google Privacy Sandbox. There's also the proposal to ban cookie walls, as they're no longer compliant with or never were compliant with the GDPR. The commissioner notes that there's a growing appreciation of the risks of excessively processing personal data and disseminating data of a highly personal nature about an individual's online behaviors. This is in line with the tensions that we can see in the wider ad tech market with browser operators and the role of personalized ad targeting. The commissioner's view is that the ICO will support the shift to less intrusive approaches to online advertising, and they'll do this by supporting any move towards the following: a move away from the current methods of online tracking and profiling practices, improve transparency for individuals and organizations, reduce existing frictions in the online experience, provide individuals with meaningful control and choices over their processing of device information and personal data, and also ensuring that valid consent is obtained where required. Finally, they need to ensure that they are able to demonstrate accountability across the supply chain. The commissioner states that the proposals looking to replace the use of cookies and similar technologies need to actually ensure that they raise the standards of data protection and privacy and not to dilute them. So to achieve this, the new proposals must be able to demonstrate that they meet the key expectations expressed by the commissioner, that they understand the broader data protection impacts, and also that they build data protection by design and by default into their solutions, which is a common theme for the ICO. So please, next slide. Now moving on to the national data strategy. The strategy was released with 4 main pillars. The first is data foundations, and that understands that by improving the quality of the data, it can be used more effectively and derive better insights and outcomes for its use. The second pillar is data skills. This means ensuring that the education system in place throughout the country can deliver the right skills, but also that people can continue to develop those skills throughout their careers. Third pillar is data availability. That means encouraging better coordination, access to, and the sharing of data of appropriate quality between organizations that operate both in the public and private sectors, and ensuring that appropriate protections for the flow of data internationally exist. The final pillar is responsible data. That's the drive of increased use of data, which must ensure that it is used responsibly whilst also supporting innovation and research. Next slide, please. These pillars are combined with the NDS missions. The first mission is unlocking the value of data across the economy. We all know that data is incredibly valuable, both for resources and other organizations. However, the NDS still believes that the full value is not being realized and wants to position the UK as a world leader in data. The first mission is to establish the conditions necessary to promote growth, whilst also ensuring that people's data rights and also intellectual property rights are protected. The second mission is securing a pro-growth and trusted data regime. Despite the recent regulatory rulings across Europe that Kolvin mentioned going against big tech, the NDS aims to make a data revolution to benefit businesses large and small, maintaining a data regime in the UK that is not too burdensome for the average company without undue regulatory uncertainty or risk to drive growth across the economy. Well, what does this mean? An environment that will encourage collaboration and competition through innovation. This can't be done without building trust and maintaining high data protection standards throughout the UK. The next mission is transforming the government's use of data to drive efficiency and improve public services. Government is undertaking an ambitious and radical transformation of its own approach, an approach that is in sync to promote best practices and standards and the standards needed to drive value and insights from data. The fourth mission is ensuring the security and resilience of the infrastructure on which data relies. So security and safety of infrastructure is obviously paramount, and there have been many high-profile breaches that resulted both in consumers suffering harm, as Kolvin mentioned, and also the large fines that have been dished out to the companies who've failed to protect customer data. This is even more important in an environment where modern warfare has seen an increasingly higher amount of state-sanctioned attacks on critical data infrastructure. Finally, we have the mission of championing the international flow of data. And this has been seen by the ICO's publication of the IDTA and addendum, as discussed by Prachi, but also by conversations that the UK is having with other jurisdictions to try and establish adequacy decisions. Next slide, please. So what are the barriers to sharing? One barrier is that there's a lack of incentives to data share. Data providers may not be sufficiently incentivized to share or provide access to their data. For example, because sharing requires them to incur costs that they're not able to get back from other organizations or individuals that benefit from increased data availability. There's also the perceived or actual risk of breaching data protection law, intellectual property rights, or regulatory requirements that can stop organizations from using or accessing this data. There's a general lack of knowledge as to how data can be used and how it can be made available. There's also the high costs associated with data sharing, and this might be because of a lack of common foundations and infrastructure that are needed to make it cost effective. Of course, there's also the commercial and reputational risks that come in hand with potential data breach or misuse of data that could be detrimental to a business or organization. Next slide, please. So what has the NDS achieved so far? Well, it's already invested £17 million into new infrastructure capabilities. For instance, launching the first phase of the digital research infrastructure program. It's launched consultations on ambitious plans for ensuring data protection regimes drive innovation whilst maintaining high privacy standards. The government's established a new central digital and data office to shape strategy. They've been working on the National Security and Investment Act, which allows for a framework and set of tools for scrutinizing investments that involve data infrastructure. There's the roadmap for cooperation on data free flow that the UK's G7 presidency has been looking after. And then there's also the mentioned adequacy decisions with high priority jurisdictions like the US, Australia, and South Korea. Next slide, please. Finally, there was the recent Queen's speech in which the government outlined its plans for the future of data privacy in the UK. And that involves ensuring that UK citizens' personal data is protected to a gold standard, whilst also enabling public bodies to share data to improve the delivery of services. There's also the usage of data and reforming regulations to improve the everyday lives of people in the UK. For example, by enabling data to be shared more efficiently between public bodies so that the delivery of services can be improved for people. And there's also designing a more flexible, outcome-focused approach to data protection that helps create a culture of data protection rather than tick box exercises. So it'll be interesting to see where and what the future holds for data protection and privacy in the UK. And with that, I hand back to Nigel. Thank you.
Thanks very much, Vlad. Well, we've reached the end of our time, and I'd like to thank you very much for joining us and hope that you found it helpful. And I'd also like to thank my colleagues, Kolvin, Prachi, and Vlad, for being on the panel. Now, we've answered a number of questions on the chat, but a quick reminder that if you have any questions following today's webinar, please do contact us directly, either by email or otherwise, and we'll be more than happy to respond in the coming days. So thank you again for attending, and we wish you a good day.